Good morning. Before we begin the webinar, we would like to acknowledge the traditional owners of the lands from which we are broadcasting today. I'm broadcasting from the lands of the Widjabul-Waiable people of the Bundjalung Nation. We pay our respects to the elders of the land, both past and present, and also extend that respect to other Aboriginal and Torres Strait Islander people attending today's webinar or watching the recording. Welcome to this Legal Aid New South Wales webinar on the Child Support Scheme. My name is Bridget Barker and I work in the Community Legal Education branch at Legal Aid New South Wales. This session will be an hour in total, which includes time for questions at the end of the webinar. After the webinar, you will receive an evaluation survey and we do really value your feedback. You will also receive an email with information about the resources that we speak about in the webinar today. I'll now introduce you to your presenter, Prema Lima, from Legal Aid's Child Support Service. Thanks, Alima.
Thank you very much, Bridget. I am here in Parramatta today, so I'd like to acknowledge that I'm on the land of the Barramudagal people and of the Darug Nation. I pay my respect to elders past and present and extend that respect to any Aboriginal people who are joining us in the meeting today. Okay, so yes, I am from Legal Aid. I'm the solicitor in charge of our Child Support Service, which is located in the Parramatta office of Legal Aid, but we cover all of New South Wales. We give people advice and assistance by telephone, and we've got some brochures here which we've produced to just tell people about our service and what we can do. You can obtain those brochures from Legal Aid from our website, or if you want to contact us at the end of the CLE session, we'd be happy to prepare that information for you. So the first thing that I wanted to do was talk about the Child Support Scheme. The Child Support Scheme is an Australian creation. Child support's an issue that affects many separated families because money and the financial support of children after separation or when a relationship breaks down is really important. So if you're working with parents or families after separation, it's quite likely you're going to come across some child support issues. Legally, all parents are responsible for the financial support or maintenance of their children. That responsibility isn't changed by them being separated or divorced, or even if they weren't in a relationship at all, still parents are responsible legally for the financial support of their children. It doesn't stop if the parents remarry. It doesn't stop if the parent is spending some time with the child. So the Child Support Scheme started in 1989, and since that time, child support's mainly dealt with by a government agency. We refer to it as a child support agency throughout this presentation, but it's really Services Australia, a government agency which is responsible for delivering Centrelink, Medicare, and also child support. I'm just going to call them the Child Support Agency or CSA. The Child Support Agency assesses child support payable between parents, and it also collects and enforces child support where this is requested. The courts now have a very limited role in relation to child support. Someone can't apply to court for child support if they could make an application to the Child Support Agency. Child support is payable up until a child turns 18, and it can be extended a little bit if the child is still in secondary education on their 18th birthday to the end of the calendar year in which the child turns 18. Applying for child support is actually very simple. The idea was that it would be given to a government agency to accept and assess those applications, so people didn't have to go to court. So there's a form that you can complete on the Child Support Agency's website. This is a picture of it here. The form, once you get into it, usually takes about 20 minutes to fill out. If a person can't complete the application online, they can call Child Support Agency to make an application on 131272, but they strongly encourage online applications. Now, it can be a bit tricky to find the application for child support on the Services Australia website. If you just type apply for child support in the search bar, the second result will be how to apply for a child support assessment. And while you're on the Services Australia website, if you just have a look for the links for separated parents on the next slide, thanks Bridget, it shows you lots of information that would be useful for separated parents, including information about the child support scheme generally and links to the application form if you need it. One of the really important issues for people with child support is it's only parents who can be assessed to pay child support, and only parents have a duty to support children. So the Child Support Agency can't accept an application unless it has satisfactory proof that two people are the parents of a child. So some of the things that we'll talk about here is what if someone can't prove who the father is? What if someone thinks that they're not the father of a child? And also DNA testing, how does it work? The first thing to say is that child support doesn't have to have a DNA test for every child to accept an application. The child support legislation says they can accept various forms of documents or circumstances for proof of parentage. So that proof can be in the form of a birth certificate that names the person as a parent of the child. They can be satisfied that someone is a parent if the parties were married at the time the child was born. They can accept a statutory declaration made by a person that acknowledges they are a parent of the child, and they have a special form that people can use, but any statutory declaration form is acceptable. They can also accept evidence that shows that the parties cohabited at some time in the period 20 to 44 weeks before the child was born. So they're in a de facto relationship living in the same house around the time of conception. Or child support can also accept a court order declaring the person is a parent. Now, if someone doesn't have any of those forms of proof, they may have difficulty applying for child support. And that's a really important thing because Centrelink expects the mother to take reasonable action to apply for child support. I'll cover that a little further before. The main thing for me to say here is that we can help people who don't have proof who the father is. We can help them with advice. We can also sometimes help them with court applications if required. Now, if someone is paying child support because perhaps they're on a child's birth certificate or perhaps they were married when the child was born, but they're doubting that they were the father, if a child support application has been accepted, they can apply to court for a declaration that they're not the father of the child. The court may actually, if it's satisfied that the person is not the father, could also order that the applicant for child support repay money that they've received from the non-father. Now, that's another matter where legal aid can give people assistance. If they're paying child support for a child that they don't believe is theirs, we can give them advice and we can sometimes help represent them in the court proceedings. Now, DNA testing is sometimes involved in those court proceedings, but it's not always necessary. Sometimes both parents know the circumstances and are fully aware that even though someone is on a birth certificate, that person isn't the child's father. But if DNA testing is required, it's important to know what sort of DNA tests you need to do. There are a number of laboratories authorised under the family law regulations to conduct DNA testing. They usually call that legally admissible DNA tests. And the difference between a legally admissible DNA test and an informal or a peace of mind DNA test is that there is proof of the identity of the person who gives the samples. So if you pay for a legally admissible DNA test, there will be statutory declarations or affidavit forms and photos of the person who gave the sample, and there's a chain of control by the person who took the sample when they send it to the laboratory to the testing to be done. So a legally admissible DNA test can be quite expensive, but then the peace of mind tests are not actually acceptable in court proceedings as proof of parentage. So people need to be careful if they're doing a DNA test that they do one that's reliable. And probably it'd be better if they got some legal advice before they went ahead and did DNA testing, because it can be quite a fraught circumstance, particularly if the children are older and have regarded that person as a parent for a long time. So I would suggest if anybody has a client who has doubts about parentage, that they refer them for some legal advice rather than the person going off and getting a DNA kit off the internet and then getting results and realising they've just opened a whole minefield of problems for themselves. Now, the next thing I want to talk about is, I think, probably the most important thing for community workers to know about, and that is the really important link between Centrelink and child support. So the child support system is also connected with Centrelink benefits. After separation, a parent with the care of the children will often apply to Centrelink for income support or family assistance payments. That's family tax benefit A and B. If they were already receiving those payments before separation, they might be applying for higher payments because they no longer have access to the income of the other party, their former partner. Now, to qualify for family tax benefit A to be paid at more than the minimum rate, a parent has to take what is considered by Centrelink to be reasonable action to obtain child support from the other parent. Generally, this means that they have to apply to the child support agency for an assessment of child support. If the person can't get child support assessment because they don't have acceptable proof of parentage, they're generally expected to take court action to obtain proof. Now, this requirement to take reasonable maintenance action, there is a period that's called the deciding maintenance period, where Centrelink will allow you to receive the higher rate of family tax benefit without penalty, even if you don't have a child support assessment. But it's not a terribly long period. It's only 13 weeks. And that 13 weeks starts from the date of separation, or if the parties were not in a relationship when the child was born, it starts on the date of the child's birth. So it's a period of about 3 months to take what is called reasonable maintenance action. And if at the end of the 13-week period, the person fails the maintenance action test because they don't have a child support assessment or they haven't got an exemption, their family tax benefit payments will be reduced to the base rate. Now, I'm not going to go to the next slide yet, but it shows you the difference between the FTB rates. But what I'd like to mention just here is you can sometimes get an exemption from having to apply for child support. That's a Centrelink decision, and it's giving someone permission to not have to apply for child support, and they can still get the higher rate of family tax benefits. So it's an exemption from the penalty of having your FTB reduced. And exemptions are only given in a limited number of situations where Centrelink considers the person has a good reason for not applying for child support and that it would not be fair to ask them to do that. If you know of someone who's reluctant to apply for child support, maybe refer them to us for advice, because we can talk through what's involved and what the risks are and what can be done to make them feel comfortable about applying. But an exemption is possible in some situations, one of them being if the other parent is unknown. It's very hard to apply child support against someone that you don't know the identity of. Or if the person cannot be located after efforts have been made. So we can give advice about trying to locate someone and what what steps can be taken to try and find someone for the purposes of proving parentage. The most common reason for an exemption is where the applicant parent feels violence or threats from the other parent or from other members of that person's family. You can get an exemption if it'll be emotionally harmful or disruptive to an applicant to seek child support. There are other matters, and some of them include cultural considerations where in a certain culture it would not be considered appropriate and it would be unacceptable and the person might be ostracised from the community. These are pretty special sorts of situations. If someone does want an exemption, it's quite common for them to be referred to a social worker at Centrelink who can make a recommendation. Sometimes we will write letters of support. Centrelink will often ask to see information to confirm that the person has a fear of the circumstances that might occur if they apply. Certainly if someone's got an apprehended violence order, Centrelink will want to see that. But it's not just limited to cases of violence, but I think it's important that people understand that an exemption is a choice. They can ask Centrelink for an exemption, and if they change their minds later and they want to apply for child support, they can, but their application can only start from the date that they make it. They can't get backdated child support. And sometimes we see really sad situations where people decide after their child's an adult that they would now like to apply for child support backdated, but you can't. It can only start from the date that you lodge your application when you decide that you want to apply. Okay, so on the next slide, we've got some information about family tax benefit rates. And I've included this here because I think it's really important to see the difference between having a child support assessment and not having a child support assessment for a family, a separated family. So the family tax benefit Part A base rate is $68.46 for each child per fortnight. Now that's a fairly small amount of money. But there is a higher rate of family tax benefit, which people who are separated and not with their child's other parent can get access to if they're taking what's called reasonable maintenance action or they have an exemption. So we'll just go through here the rates. It depends on the age of the child. The maximum rate for each child per fortnight, if they're 0 to 12 years, is $213.36. So you can see that's a huge difference between $68.46 per fortnight and $213.36 per fortnight. If the child's 13 to 15, it's even higher, $277.48 per fortnight. And then if a child's 16 years or older and in study, they can get, their parents can get $277.48 per fortnight if the child meets the study requirements. So just thinking about the sort of circumstances that separated families are in, if they're reliant on an income support payment or just doing part-time work, then family tax benefit is likely to be a really important part of the family's income. And one of the saddest things that we see is people who, when their child's quite a bit older, discover that they could have been getting a higher rate of family tax benefit if they'd just been able to meet the reasonable maintenance requirements for family tax benefit. So by making an application for child support, someone might think, well, the father's not employed, all I'm going to get is $8 a week, it's really not worth the hassle. The real financial incentive for them is that they might not get very much child support, but they would get a higher rate of family tax benefit, Part A. Now, those rates that I'm showing you can be affected if the person is getting income from other sources, from earnings, for example, but it still does make a difference. So I think if you see clients who are struggling financially, who don't seem to be getting enough family tax benefit, one of the first questions you can ask them is, are you getting child support? And if they say that they aren't because they can't get proof of parentage or they don't know where dad is, please refer them to legal aid and we can give them some advice about their options. Now, do you want to flip back, Bridget? Because I'm not quite ready for that. This is actually a lot of information. The interaction between child support and Centrelink is very complicated. So if you do receive child support, it can affect the rate of family tax benefit under the maintenance income test. Centrelink will work this out automatically, but each dollar of maintenance income that a person gets above the maintenance income free area can reduce their family tax benefit by 50 cents in the dollar. The amount of child support you can get before your FTB rate goes down is around $65 a fortnight. And after that, if you get more than $65 a fortnight, 50 cents in the dollar is taken off your FTB. Those amounts are adjusted if you've got more than 2 children, and also if you've got a blended family where 2 parents each receive child support for some of the children in the household, the maintenance income free area is doubled to $130 a fortnight. So family tax benefit really closely linked to child support. It's set out reasonably clearly on the Centrelink website, but the golden rule, the one that I like to tell people, is you should never be worse off if you get child support than if you just got family tax benefit on its own. So you should always be financially better off if you're receiving child support and family tax benefit. Thanks, Bridget. Now, the next slide, the child support formula. I said that child support works out how much should be transferred. They do this using a child support formula, and the formula has 3 important components. These are the cost of the children, the income of each of the parents, and the level of care. So the cost of the children is not how much you spend on your individual children or how much someone has decided children cost. There isn't a same amount for all children. There is tables in the child support legislation which are based on research into what parents typically spend to meet their child's basic needs, according to the income of the household and the ages and number of the children. So the costs of children are numbers that have been decided based on research, and the research found that in higher income households, people spend more on their children, but they spend less as a proportion of their income overall than families on lower incomes. So the tables are broken into the numbers of children, the ages of the children, and the income level of the household. Now, the income of each parent is calculated using their taxable income, the most recently available taxable income, via the Australian Taxation Office. This says the income of each of the parents. It is possible to apply for a child support assessment if you're what's called a non-parent carer. Your income's not taken into account in working out how much the parents should pay you for looking after that child. So the income of each of the parents is obtained from the tax office. It's adjusted. There are some things added back in. For example, if someone's got negatively geared real estate, then the loss from negative gearing is added back to their taxable income to make it fairer. They're not able to offset losses for investment purposes against what they should be paying to help support their children. The level of care is, or the care percentage, is worked out on the basis of the number of nights that the child typically spends with each of their parents. So the levels of care that will affect child support, you have to have at least 2 nights a fortnight care of the child, or 1 night a week, before it will affect what child support you have to pay. And then it goes through progressively through what's called regular care, shared care, primary care. Primary care is where you have the child between 65 and 86 nights a fortnight. If you have the child living with you for at least 65% of the, 65 nights a fortnight, 65% of the nights, which is 10 to 12 nights per fortnight. If you've got the child with you at least 10 nights per fortnight, you don't have to pay child support to the other parent. And primary care is where the parent has the child with them for at least 86% of the nights. So if you see one of those confusing child support notices of assessments, all of this information is set out on there. It says what the costs of children are. It says what the income is that's been used to work out the child support for each of the parents. And it says what the care percentage is that child support is using. Now, that might have sounded really complicated, and it actually is a very mathematically challenging thing to work out. But luckily, Child Support has put an estimator on their website, and we've got that here. You can just go onto the Services Australia website and type in child support calculator or child support estimator. This will pop up as one of your search results. It's a really useful tool. Parents can use it to work out what they think they might be able to receive from the other parent, or what they might be liable to pay the other parent based on their own best information about what the other person's income is. And then they can do variations and look at, well, what if my income was higher? What if the other party's income was higher? What if the children spent extra nights with me? What if they spent less nights with me? So it's a really useful tool. It isn't linked to your child support account. You can put in bodgy names if you like. It's absolutely just for the purposes of you working out what you are likely to pay or likely to receive child support. Now, collecting child support. When child support accepts an application, it calculates and issues that formal notice of assessment showing how much is to be paid. The parent entitled to receive the payments, who's usually the one who's made the application, is offered a choice about how to collect those payments from the other parent. So if the payee chooses private collect, this means that child support agency takes no role in collecting money from the other party. It's left up to the parents to arrange how the money is to be transferred by the payer to the payee. The CSA doesn't monitor how much child support is transferred in private collect cases. If the payee chooses agency collect, what they're doing is making child support agency responsible for collecting child support. So child support will, in an agency collect case, be calculating the amount of child support to be transferred. And also it will be responsible for collecting the money and transferring it to the other parent when it's received it. The CSA does that by sending monthly accounts to the payer. They charge penalties if the payments are not made on time, and it's got a range of administrative enforcement measures available if payments are not made. The payer has to pay their child support agency, pay their child support to the CSA. You want to go back, Bridget? It will be a while. They should not be paying direct to the payee, although if they do, there is an option for them to ask child support to credit that against their liability. Talk about that a bit further on. Now, currently, just under 50% of cases are private collect. The CSA encourages payees to choose private collect as long as they've got a reasonable relationship with the other parent and they're able to contact them to arrange payments. However, at the beginning of a case, the payee is entitled to choose which is the most appropriate method for them. Private collect can be more flexible, and there won't be delays at the beginning of the case while the payments are set up, but it's really not appropriate unless the payee is confident that the other parent will pay child support in full and on time. Private collect can also lead to problems if the child support assessment's not based on accurate information about each parent's income, because they haven't lodged tax returns. Because if child support amends the assessment when that income comes in, then the other party is responsible for chasing up any arrears, and that can be very difficult. Agency collect is usually the most appropriate collection option if there's a history of family violence or financial control, or whenever it's anticipated from the outset that there will be problems in the collection of child support. Agency collect reduces the need for the payee to communicate with the payer about money. The payee can decide to switch between collection methods if their circumstances change. They can do that easily by telephoning the CSA or applying online for the CSA to start or stop collection using the MyGov app. Now, if the child support payments are not up to date, the Child Support Agency should always accept the payer's application to switch from private collect to agency collect. This is called opting in. The CSA can also collect up to 3 months arrears if someone opts in because the payments were behind. In exceptional circumstances, this could be extended for 9 months, but there's a very hard limit on the amount of arrears that can be collected. So it's important, if payments aren't being made on time in a private collect case, that you switch to Child Support Agency collect as soon as possible. Now, enforcement of child support. So I said that CSA has broad administrative powers to collect child support payments. These powers can be used without them having to apply to court, and they include adding penalties for late payment as an incentive for people to pay on time, making direct deductions from the salary or wages payable to the liable parent, making direct deductions from Centrelink benefits. They can do collection from third parties, including from deductions from bank accounts held in the payer's name. They can intercept the payer's tax refund. That will happen automatically if the person is in arrears. The tax office just notifies child support there's a refund, and child support will say, yes, there's unpaid child support. We'll take that. Thank you very much. And in certain circumstances, sometimes Child Support Agency will issue what's called a departure prohibition order, which will stop people leaving Australia until they make satisfactory arrangements to repay their debt. So that can be quite an effective means of encouraging payment if someone has planned a holiday, needs to travel for business, or might be moving overseas. They won't be allowed to leave the country unless they settle their child support debt if there is a departure prohibition order in place. The Child Support Agency can also start court proceedings to enforce unpaid child support. I really do have to start this section by saying it doesn't happen very often. Enforcement proceedings are commenced usually in the Federal Circuit and Family Court of Australia. That option is used in very few cases, and generally only where there's a real prospect of the child support debt being repaid in full. Most commonly, that's where the payer owns real property in their own name, which could be sold to pay substantial debts. It's terribly important that people who are entitled to child support, if the child support is not being paid on time, that they keep in touch with Child Support Agency and that they try to provide as much useful information as they can about the other party's circumstances to help child support with collecting. I know it's frustrating and people don't get a lot of feedback when they pass this information on to child support, but in almost every case, they will follow up that information and see if they can use it to help collect. So keeping in touch with the agency when they're supposed to be collecting on a regular basis and just being a bit of a nuisance is a good idea. And if you find out something like the person has purchased property, sold property, started a new job, find out where they're banking, pass that information on to child support, and they'll see if they can use that to help them to collect the money for them. I mentioned before that if you've got a Child Support Agency collect case, the payment should be made to Child Support Agency and they transfer them to the other parent. But it is possible for someone to ask child support to credit money paid direct to the other party, but you have to be able to show that when you paid the money to them, that both of you intended it would count towards the child support debt. So you're not going to be successful in having money credited if what you've done is you've given the kids some money and asked them, said to them, spend this, and then you go and ask Child Support Agency to credit it against the money that you're supposed to pay CSA to be paid to their parent. There are a limited number of payments that if you pay them, you could ask them to be credited as non-agency payments without getting prior consent from the other party. But these include school fees, uniform costs, and some medical costs. but there are limits on when those can be used, and you have to, you can only use them to satisfy up to 30% of your child support debt, and you have to pay the other 70% in cash. I would advise people not to do this unless they've already checked that it's definitely going to be credited, and they think about whether it's a good option for them when they can be certain that the debt will be satisfied if they pay the money direct to child support agency. Now, one more thing. It's really important for people who are receiving child support or supposed to receive child support and getting Centrelink payments that they understand that the way they've chosen to collect the payments will affect their FTB. So if you've chosen to collect privately, Centrelink assumes that you're receiving all of those payments in full and on time. They don't ask you to prove it. And if you show that you're not, they're not going to give you any extra money. You always have your FTB based on the amount of child support you're supposed to be receiving. So that means if you're in private collect and you're not getting those payments, you're actually doing yourself and the children a disservice because you're getting less FTB as well as not getting the child support. So if the private payments are not being paid on time and in full, it's important to ask CSA to start collecting. Otherwise, you're suffering a financial penalty in terms of less family tax benefit. Now, the next slide, Bridget. I've talked about the assessments and how they're made. It's based on the care percentage, the costs of children, and the income of the parents. Now, about every 12 to 15 months, when someone, either parent, lodges a tax return, a new child support assessment will issue based on the new taxable income details. So generally, the income is fixed up each time a person lodged a tax return. And so the child support is reassessed to keep pace with changes in the parents' incomes. But during that period, there might be some things that alter, and they're not going to be fixed up when the tax return is lodged. If, for example, your income drops suddenly, if you lose your job, and that reduces your income by at least 15%, you can lodge what's called an income estimate. And that applies to both parents, to the parent who's got the care of the children and is entitled to payments, and also to the person who is paying child support for those children. So if your income suddenly changes, you can lodge an estimate as long as your income is going to be reduced by 15%. That income estimate applies only from the date that you lodge the estimate, and you're asked to estimate what you will be earning for the rest of the financial year. And at the end of the financial year, child support will compare your taxable income to what you estimated. And if your estimate is not accurate, if you estimated too low, you'll be charged extra child support, and you'll also be charged a penalty for getting the income estimate wrong. The way to avoid that is to update child support when your income changes next. So once you've used an estimate, make sure you update your estimate. Another thing that might happen during the course of a child support period is new care arrangements. So if the children previously were spending one night a week in the other parent's household, and then they changed to, say, 3 nights a week, a new care pattern, the parents just need to advise child support or Centrelink for family tax benefit of the change care percentage. And in this circumstance, either Centrelink or child support, whoever was told about the change care percentage, will investigate and then make a new care decision. So the care arrangements can be adjusted by the parents reporting and that care being confirmed by the other parent. And if they can't confirm it, then they'll be asked to provide evidence to support what they say is a new care percentage. Another important way, another thing that you should report is if you have a new child born in your new household. So if someone's repartnered, their new partner has a new baby, that child is considered a relevant dependent for the purposes of child support and will affect the rate payable for the first family. And that information should be reported to child support. And for all these things, income estimates, care arrangements, and new dependent children, it's important to report promptly because there is a time limit and you won't get a backdated adjustment if you delay the report. Now, change of assessment in special circumstances is not just ringing up child support and telling them that something's changed. It's actually quite an involved process where you have to complete an application form, which is about 12 to 14 pages long, and you have to explain what the reason is for the change of assessment. And the change of assessment reasons are set out in legislation. There are 10 of them. They're all listed on the form. They include things like there's high costs allowing a parent to spend time with one of the children. The child has special needs which cost extra to support them. There are high costs associated with educating or training the children in the way that the parents expected. That typically is the child is attending a private school that both parents wanted them to attend at an earlier stage. If the child is earning their own income such that they're self-supporting, that could be a reason for a change of assessment. If the payer has transferred a sum of money to the payee for the support of the child in lieu of child support, so not a property settlement, but money transferred for the support of a child, that could be a reason for a change of assessment. It could be a reason for a change if the payee has high childcare costs. Could be a reason if a parent has a medical condition that means that it costs them extra to support themselves. If a parent has a duty to maintain another child or another person, that's a legal duty. So there would be court orders in most situations, or perhaps someone's new partner is not working because they've just had a baby. They could have a duty to support them for a limited period. And then the most common reason for people to apply for a change of assessment is where the assessment's unfair because of the income, property, financial resources, or earning capacity of either or both parents. And that's typically one where someone is self-employed or is working in a partnership and income splitting with a partner, or perhaps someone suspects that they are not declaring all of their income to the tax office. This is a typical situation where someone might apply for a change of assessment on the basis that the assessment's unfair because of the income or financial resources or earning capacity of the other parent. Now, if people apply for a change of assessment, they've filled out that very big application form. It is sent to the other party so that they can respond, and then the matter is allocated to a delegated officer in child support who speaks to both parties over the telephone about the matter, and then will make a decision. And they will write a detailed decision which sets out whether they've decided to change the assessment, and if so, why, and what the new assessment will be. The CSA can consider making a change of assessment going back up to 18 months. So it's a big deal to apply for a change of assessment for a lot of people, but it's much simpler than it would be if they had to go to court. If you wanted it to be a change for more than 18 months, you'd have to go to court to get leave. And I'll talk about that a bit later. Now, there are objection rights to most decisions that the CSA makes. So objections have to be in writing and explain why the person thinks the decision is wrong. They're supposed to be lodged within 28 days of the decision being made, although they can apply for an extension of time if they've got good reasons for delay. And then once the person's been through the objections process, they've got a right to apply to the Administrative Appeals Tribunal for a review. The process of getting a decision reviewed, putting in an objection and going to the AAT can be quite complicated. These are things that Legal Aid can give people advice about if they just want to give us a call, and we'll make an appointment for them to speak to a solicitor about reviewing a child support decision. The next slide is about child support agreements. people, beyond the encouragement or incentive to apply for child support through getting extra family tax benefit, they're not forced to apply for a child support assessment. They might want to do, in some cases, a private arrangement. So there can be informal private arrangements that parents make for transfer of money or not for a child. But for many people, the link with Centrelink means that that's not really an option for them, because they might think that the arrangement is fair between them and the other parent, but the government expects them to be getting some child support to limit what the government has to pay in terms of FTB. Another sort of arrangement is that people can choose to collect privately, and then if they collect privately, it's up to them to make sure that they're collecting the right amount of child support and then applying for CSA Collect if that's not working out. The most formal sort of a child support agreement is set out in the child support legislation. They're required to be in writing. They're called binding or limited child support agreements. They have to meet certain formal requirements. People should speak to a solicitor before entering into one, particularly because the agreements can be very hard to get out of. Once you've made an agreement and registered it with CSA, you might have to go to court to have it set aside. And if you make a binding child support agreement, then family tax benefit is paid on the basis of what you would get in child support if it were not the agreement. So again, child support agreements, complicated, get legal advice, not really suitable for many people, but they can be a good option for some families. Now, child support, you don't often have to go to court. The whole scheme is aimed at people not having to use the court processes except in particular situations. The things that people might go to court for is to get leave to apply for a change of assessment for up to 7 years, because it's more than the 18 months that the CSA can look at. They might want to seek a declaration of parentage if they haven't got proof of parentage or if they dispute that they are a parent. The appeals are not usually to court. Appeals are through the objection process and AAT. So in most cases, you won't go to court unless you're unhappy with the decision that the AAT made, when you would have a right of appeal to the court. Stay orders are a temporary option for people who are challenging a child support decision. A court can say that while that decision is being looked at by the AAT or through an objection, that the child support payments will be suspended or altered temporarily while the matter's resolved. And then it's possible for a court to hear an application for enforcement of child support. That can be brought by the Child Support Agency. I've already mentioned that doesn't happen a lot, but it is possible for a payee entitled to child support to take their own enforcement action in court. Please, if anyone's contemplating that, refer them to legal aid to get some advice. They will need to understand what the formal requirements are and just what forms they need to apply and what the prospects are of them being successful. Now, some of the other child support issues, people can apply for lump sum child support if the circumstances are such that the other party is unlikely to pay, but there is an asset that could be seized. So typically we see this in cases where a party has moved overseas and is outside of the reach of the Child Support Agency, but they have property in Australia. Lump sum child support is an application to a court. They're not made very often. Those orders are always considered to be the exception, because child support should really be paid on a regular basis as a periodic amount to help support with day-to-day costs. But it is an option. It might happen as part of a property settlement. In any case, people should get legal advice if they want to find out about lump sum child support. Another child support issue is where a child is over 18. If they're still in secondary education in the year that they turn 18, the child support assessment can be extended. But Beyond that, it's a matter where a parent has to apply to court for an order for child maintenance. And the child maintenance order can only be made if maintenance is necessary to allow the child to complete education, or if the child can't support themselves and needs financial support because they have an illness or a disability. Court orders for maintenance for children over 18 can be registered with the Child Support Agency for collection, as long as the order says that the person to be paid is a carer. If it's the child, then the Child Support Agency can't collect the money for them. It's a little blip in the child support scheme. Child Support Agency can also collect overseas assessments and orders. It is possible to apply for a child support assessment in Australia if your partner lives overseas. Again, really complicated, but please, if you know someone in this situation, if they speak to Legal Aid's Child Support Service, we can give them advice about whether that's an option for them. Now, I can see I've talked a lot, Bridget, and we've got a case study. Will we do that?
Yeah. I just note the time. I just thought I'd let the audience know that there are a couple of case studies, and I think that they might find them very helpful. So we may just run sort of 10 minutes over time. So just letting people know, if you have to leave, you will get a link to the recording afterwards, so you'll be able to come back and listen to the information about the case studies if you do have to leave. And please leave any questions. If you use your name, we can always email the answer if you've had to leave before the end of the webinar.
Okay, so the case study. Katia and George separated about 6 months ago. They've got 2 children who are now aged 10 and 8. Recently, Katia and George attended a mediation session at a family relationship centre to try to resolve parenting matters. Katia and George got along well at the session, and they made some great progress in the best interests of their children. They ended up signing a parenting plan that provided for them each to have 50% care of their children. Just before the mediation ended, Katia said to George, "But what about my Centrelink payments? If you take half my payments, I can't get by." George said, "I don't care, you can have the whole lot. Just don't go chasing me for child support. I can't pay it if we're both looking after the kids." So, what issues do you see arising in this situation? So Katia and George sort of went into the mediation with one set of things, one set of expectations, but some of them, they haven't thought about child support. So we've got some questions here in our poll. I'm not allowed to vote, apparently. So first one, what do you think? Is no child support payable if parents have 50-50 care of the children? True or false? The second one, Katia and George can arrange what they like about child support if it's agreed. True or false? The third one, Katia can't get any child support from George after this conversation. True or false? And then the fourth one, George can ask Katia to sign that she won't apply for child support. True or false? I hope you can see that. Is that all of the quiz questions, Bridget?
If Katia signs this, CSA must refuse any... Did you read that one out? Sorry.
No, I didn't.
Oh, okay.
No.
If Katia signs this, the Child Support Agency must refuse any future child support application. So true or false? And I can see people are answering those at the moment. I'll just give them a little bit more time to finish, and then I'll end the poll and we can share the results.
Thank you. Okay. So with this one, people thought no child support is payable if parents have 50-50 care. 25% thought that was true and 75% thought that was false. It's actually false. You have to have at least 65% care of a child to not have to pay child support. So in this situation, the person with a higher income would end up having to pay child support under a child support assessment with 50-50 care. The second one, Cartier and George can arrange what they like about child support if it's agreed. 78% thought that was true, and it is true. 22% thought it was false. It's also a little bit false because, yes, they can as long as they agree, but having agreed something at the beginning doesn't stop you from changing your mind later. So Cartier and George might be very happy right now, but 6 months' time, Cartier or George might decide that they want to apply for a child support assessment, and the other party is going to be a bit miffed when that happens. Question 3, Cartier can't get any child support from George after this conversation. I can't see what I have to scroll down. I do. There you go. Cartier and George can't get any. 9% of people thought that was true. 91% thought it was false. It's certainly the case that Cartier can just go in and make an application for child support if she wants, regardless of what she and George discussed in this mediation session. And whether George can ask Cartier to sign that she won't apply for child support, certainly he can, but whether that agreement is binding, it will only be binding if it's in the form of a binding child support agreement. And to be a binding child support agreement, they have to get legal advice from 2 solicitors who gave them advice about the circumstances and how this agreement would affect their entitlements and obligations. So a document signed in this mediation session is not going to be a binding child support agreement. And then the last one, if Cartier signs this document, CSA must refuse any future child support applications. That's false. If Cartier signs a parenting plan that says she won't apply for child support and then she goes and applies for child support will accept that application. It's not binding. Okay, so we would suggest that people who go to mediations and are talking about child support issues should get some legal advice. And if we go to the next slide, what we would cover in legal advice, 50-50 care doesn't necessarily mean no child support. We'd ask Cartier and George to think about how they're going to share the costs of school fees, excursions, uniforms, shoes and clothing, haircuts, extracurricular activities. It's a good idea for parents to at least think about this in discussions. And even if it's not written down, they'll have had the conversation and they'll know what to be expected. If George is earning more than Cartier, he'll be assessed to transfer some child support. If Cartier doesn't have a child support assessment, she'll only get the base rate of FTB Part A. If she applies for child support but she chooses private collect, Centrelink will assume she's getting the full amount. If George and Cartier want to make a child support agreement, they'd have to think about what kind, limited or binding, and they will need legal advice, especially about how to get out of it if things change. And limited agreements can't be for less than the child support assessment, so you can only make an agreement to get more. And binding child support agreements need a certificate of independent legal advice. And then for limited and binding child support agreements, Centrelink will work out FTB for whoever's receiving it using the notional child support assessment and not the agreement. So there's lots for people to think about when they are having discussions about how they're going to do child support between themselves. Okay, next slide. So the key takeaway messages from this session, and I hope these are helpful. If you don't have a child support case, you might miss out on family tax benefit. You should ask Child Support Agency to start collecting if child support is not being paid or paid on time. You should always lodge your tax returns and tell Child Support Agency about changes to income and care arrangements. You should get legal advice before negotiating a child support agreement. And Legal Aid New South Wales gives free legal advice for people who need assistance. If you wanted to refer people to our service for help, these are the direct numbers for the Child Support Service, and this is our email address. Those details are in these brochures, which we can send to you. But pretty much if someone rings up Legal Aid and they say they've got a need for advice about child support, there's no wrong place to call. We have a triage system where all child support calls will be transferred to our team who will book in an appointment. So just contact legal aid is the real important message if you need advice about child support. We've got a range of fact sheets which are all available on our website about particular problems that people might have that they will need to apply for a court process or administrative appeals tribunal process. These fact sheets got step-by-step what people need to do, and you can still get advice from us if you have questions after reading them. And then a little plug for our Victorian colleagues who've recently released a new resource called Child Support and the Law. The scheme is a national scheme, so the information in this booklet is good for people in New South Wales. The only bit that's not good is don't ring legal aid in Victoria if you want advice. Contact legal aid in New South Wales. I'm sorry, I talked for too long. So we might not have time for questions as planned, but if anyone has a burning question that I haven't covered already, I did try and make sure that the session would cover all of the questions asked before people attended. So some people sent registration questions and I've covered those in the presentation, I think. But do we have any others that people want me to look at now?
There are a few, Alima, yes.
Okay.
So Marie has asked, if the other party fails to pay the required level of child support regularly, will Centrelink know, and how soon is the family tax benefit amount adjusted?
It's a really good question, Marie. So if the party fails to pay their required level of child support and it's private collect, Centrelink will not know, and it won't be adjusted, and it's up to the person who's entitled to the payments to actually apply to Child Support Agency to have them collected. Now, once someone is a Child Support Agency collect case, Centrelink will work out their FTB over a year based on the actual amount of child support that is transferred. But during the year, they'll assume that you're getting the right amount, and then at the end of the year, they'll balance the payments and pay the difference. If you're not receiving your child support, though, and it's a high amount and your FTB is low and you can't wait till the end of the financial year, a person can contact Centrelink, say, I'm not getting the child support I'm entitled to. I want you to pay me on the money that's actually received. Now, Centrelink can do that. It's called being paid by the disbursement method. And if someone asks to be paid this way, Centrelink will make sure they understand that it's possible that they might be overpaid at the end of the financial year. But if you're not being paid and your FTB is being reduced, it's the best option. And if you are overpaid, it will be because you've received some child support, so you probably have the resources to pay it back. What about stepchild? Does the stepfather need to pay child support is the next one. And the answer is no. No, you don't have to pay child support for a stepchild. It is possible for someone to apply to court for a child maintenance order for a stepchild. Those orders are made very rarely, but the child support scheme only covers natural children. So your obligation is to support your own children. Or adopted children, or children that are yours legally through artificial conception procedure. But generally, you have to be legally a parent and not a step parent to pay child support for a child.
Do you want me to read that out? So
if
child
you would,
support,
yeah.
that way the rest of the audience can hear it while you get a chance to read it as well. So child support is always assessed on the previous year's taxable income. If the primary carer didn't work last year but returns to work this financial year and is reasonably certain they will be overpaid child support this year, can they have it adjusted so they don't end up with a debt?
So this one is child support is initially based on last financial year's taxable income. If the primary carer didn't work last year and they go back to work this financial year, their child support will not automatically increase until they lodge next year's tax return. But it is possible for the other party to apply for a change of assessment if they twig to the fact that someone's gone back to work and say, hey, that's not fair, it's based on her income when she wasn't working and now she's back at work. If your child support is based on last year's taxable income, you don't have to tell child support when you go back to work. You'll be caught up with when your tax return is lodged. But if you've lodged an estimate so that your income is lower than it was last financial year, you have to tell child support when your income changes. So if you're using an estimate, you always have to tell them when your income's gone up. If you're just based on last financial year's tax return, you'll catch up when the next child support assessment issues after your tax return is lodged, and you don't get overpaid unless you've used an estimate. I don't know if I managed to explain that simply. This is the sort of thing where people would do best to come and get some legal advice so we could sit down and try and talk about specifics rather than in general terms.
It's quite a complex system, isn't it?
It's a very complicated system.
Okay, so Gabby's asking, if somebody has CSA Collect and the payer is still not paying, how does the payee get them to enforce the debt, and how long does it take them to engage in wage garnishing and the other enforcement options?
Okay, so well, the first thing is child support agency needs to know where the payer is working. So if you know where the payer is working, you should tell child support agency as soon as you apply for child support. And you should let them know if you discover that they've changed jobs. Child support agency doesn't really like not being able to collect debt. So if you give them information that will allow them to enforce the debt and the person is behind, they should contact the employer fairly quickly. So child support, if it's more than about a month overdue, and the person doesn't respond to calls and requests for them to pay the amount, they should just start deducting from the employment payments. I would expect that probably would happen in about 2 months, but don't sit there waiting for it to happen. Report the information, call child support agency, say you're concerned that the person isn't going to pay. They'll give them a bit of time to comply. They'll give them an opportunity to negotiate a payment arrangement. But if they fall over and don't meet that payment arrangement, they should start wage garnishing straight away.
Thank you, Alima. This next question is asking about the impact on the payer if the payee has another child in a new family, in a new relationship. How is the amount paid by the payer impacted up or down when there's a child born to the person that receives money, but it's not the child of the person who's paying child support?
Yeah, I think we've got a group of experts in the audience asking these questions. So the impact on the payer, it's actually an impact on either parent if they have a child. What happens is their allowable income before the child support is worked out increases. An extra child in the household means that you're allowed extra income as a self-support amount. And that means that if the payee has another child that's not the child of the payers, their allowable income will increase. And if their income affects the amount of child support that is payable, then that could mean that they will get more child support from the payer. So if the payee has another child and the payee's working and has an income that will affect the rate of child support payable, it could increase the amount the other party has to pay them. It's the converse if it's the payer. If the payer has another child, they will have extra allowable income. Their income might be the same, but the amount that they have to pay to the payee could be reduced because they have an extra child that they have a legal duty to support. And why? Because the scheme treats all children of parties equally, and the person who has extra children has a duty to support more mouths, and that's the way it works. I know people find this a bit contentious, but that's the way the scheme has been drafted. If you want to have a play around with it, use the calculator and the calculator will show you the effect of having another child who is not a child of the two parents in either of the households. Okay, I think I've lost some.
So the next question is, a child is receiving special benefit because the father has not yet provided his Australian citizenship papers. So the child is not yet an Australian citizen. Is there any way this child can receive child support? And what are other ways?
Lovely question.
Yes.
Child support is not only payable for Australian citizen children, it's payable for children who are here in Australia if the liable parent is also here or in a reciprocating jurisdiction. So if you are assisting people who don't have Australian residence but have an Australian child, or indeed have a child that doesn't have citizenship recognised, they can still apply for child support. And if they need help improving paternity, we can assist them with that. So not being an Australian citizen doesn't exclude you from the Australian Child Support Scheme, and nor does it exclude you from legal aid helping you to get proof of parentage. And if you're not entitled to receive family tax benefit yourself, someone here understands that you might be able to get special benefit for the child, but you can also get child support for the child.
Thank you. Timothy is just querying about poll question 2. I presume the parties should be notifying the child support agency of their agreement, whatever it might be, so it's noted on the records.
In fact, child support must be told if there is a child support agreement that's a formal binding child support agreement or a limited child support agreement, that they have to be registered with CSA. Poll question 2, if parties have made an agreement that isn't a binding child support agreement, they can tell child support about it, but it doesn't necessarily mean that child support won't accept a child support application if it comes in. But they should be telling child support about the care arrangements that they've agreed. So certainly it's important Child Support Agency knows that there's 50-50 care, and certainly Centrelink needs to know there's 50-50 care. But unless it's a binding child support agreement, it's not going to make a difference to the amount of child support payable.
So then there was a follow-up question. Yes. Is it correct that the parties can't enter into a binding child support agreement unless both parents are eligible carers, which means they have at least 35% care?
Well, a binding child support agreement can actually be made by two parents who have no care of the child that say what they're going to pay a non-parent carer. So a binding child support agreement is not only for someone to receive, but also for someone to pay. But I think what Timothy might be talking about here is that if someone hasn't got at least 35% care, they can't have a child support agreement that says they're going to receive payments from the other person. So you can make a child support agreement, but Child Support Agency won't collect the payments if you're not, if you don't have at least 35% care, and the agreement will in fact end or be invalid because you can't agree to pay child support unless you're an eligible carer. Timothy, you're one of the experts in the audience, I can tell.
Mary is concerned about parents who might agree to pay school fees but not know whether that is child support under an assessment. What do you suggest we tell them?
I think that if they're agreeing to pay school fees, they should get legal advice about how that will affect their child support, because one, it's a possibility that it might lead to a change of assessment in special circumstances. It's possible that it could be credited as a non-agency payment, or it could be that it's not taken into account at all. It's a complicated question, so refer them to a solicitor for advice, and legal aid does that sort of advice.
I'm pretty sure that you answered this, but can a person who owes child support be stopped if travelling overseas?
They the mere fact that they've got a child support debt doesn't stop them from travelling, but if Child Support Agency has issued a departure prohibition order, it does mean that they're going to be stopped, and it's actually an offence for them to try to leave. If someone is owed a large amount of child support and they know that the other party is going to be travelling overseas, that's the sort of thing you ring Child Support Agency up straight away. 131272, please issue a departure prohibition order.
Another question from Samantha. If you're applying for child support assessment, do you need to put down a stepchild as a dependent child?
No, they're not considered a dependent child. There's a very, very small chance they might be taken into account under change of assessment reason 10 if there is no person who no parent who can financially provide for that child, but they're not considered a relevant dependent child under the formula.
Thank you so much, Alima, for your presentation and for sharing all that information in response to the questions. And to let people know, this webinar is being recorded and it will be uploaded onto Legal Aid's YouTube channel in the next day. You'll also receive an email from us with links to where you can find all the resources that were shared in the presentation. I did send a PDF copy of the presentation out prior to the webinar, and I can send that again following the webinar today. So thank you for those who've been able to stay on a bit longer, and thanks, Alima. We'll close the webinar now.
Thank you, Bridget. Bye, everyone.
Bye, everyone.